a legal loophole that's enabled some drivers to escape prosecution for holding a mobile phone while driving is to be closed by the government. So under existing laws, I didn't know this, lawyers have been able to argue that filming, taking photos or browsing the internet isn't illegal because the phone isn't being used for interactive communication. Here in Kent early this month, the Kent Police Federation chairman Neil Menney called for a cultural change to educate drivers not to use their phones whilst behind the wheel. Neil Menney stated there's been a number of recent traffic collisions in Kent, including a tragic death caused by people distracted by mobile phones. Let's speak to Sunil Rupachina, who is motoring lawyer and at Kent Traffic Law. Sunil, morning to you. I wasn't aware there were loopholes. I always thought it was simply holding your mobile phone, almost looking at it was an offence.
Morning, Ian. No, that's not right. Although from the way the police enforced the law, you would have thought that it was. What the current law actually does is prohibit the use of a mobile phone for making or receiving interactive communications. So if you're, in effect, using the internet to send or receive a text or an image, or you're making or receiving a phone call, and you touch the phone whilst you're driving in order to do so, then you commit the offence.
So if I pick up... Now, go on, carry on, Sunil, sorry.
Yeah. Sorry, so up until now, what the police had been doing was prosecuting anyone who touched the phone for any purpose whilst they were driving. So, for example, if they were taking a photograph or filming, which doesn't involve an interactive communication, they would still charge you. And by and large, the magistrates' courts were convicting you. But what happened was there was a case this summer in the High Court, and they clarified that that is, in fact, an incorrect application of the law, that it is, in fact, only for making or receiving interactive communications. So looking at the Times this morning, what the government is trying to do is to close that loophole so that anyone touching a phone, whether it's for taking a photo or filming, is caught by the law.
So previously, Sunil, if I'd been watching an episode of Peaky Blinders on my phone, which was mounted to the dash, would that have been illegal? Technically.
Well,
because I'm not communicating.
Under this current interactive communication device law, if it's attached to the dashboard and you're not touching it, you're not committing an offence. You have to touch it whilst you're driving. If you have a completely hands-free kit and it's mounted, you're not committing the offence anyway.
Okay.
Now, if you're watching an episode, here's the catch. Let's say you downloaded it a month ago, and so it's stored on your phone. You then jump into the car, you pick up your phone and you're watching it. Technically, you're not actually using the phone for an interactive communication because it's already downloaded onto the phone long before you started the journey. So this is why the government's trying to close this loophole.
Which many people would say, Sunil, that's reasonable because based on what you're saying, if you apply the law absolutely rigidly, I could legitimately pick up my phone while driving, put my hand sort of towards the windscreen and film or take photographs of the drivers around me if I thought there was a road rage moment or something going on. I could do that with impunity.
Yes, you could. Under this particular law, what motorists have to understand, though, there are plenty of other laws, such as driving without due care and attention, under which you might be prosecuted for whatever purpose you were touching a phone whilst you were driving.
But then it becomes really tricky, doesn't it? Because you've got cars that are built with touchscreens that enable you to answer a call. Legitimately, one might have thought, by pressing the touchscreen. Where does that sit within this? You're not touching the phone, but you're touching the screen that's connected to the phone in order to allow you to make the call.
Well, here we have to be particularly careful about exactly what we're talking about. If you have what they term an interactive communication device and you touch it, even if it's mounted, if you're using it for an interactive communication, you are committing the offence. What I'm saying is if it's mounted and you don't touch it, so, for example, if you have controls on your steering wheel, then even if you're using it for an interactive communication, you're not committing the offence. So you have to be particularly careful because the law doesn't actually prohibit. It doesn't use the term mobile phone as such. It's prohibiting the use of an interactive communication device for an interactive communication function.
So I would still be breaking the law then, wouldn't I, if I was touching my steering wheel or a touchscreen?
No, if you touch the steering wheel, it's not classed as touching the interactive communication device.
Oh, I see. So it's the source, as it were, rather than the conduit with which you might apply it.
This is why, with hands-free kits, people can still happily have conversations without breaking the mobile phone law, which is what obviously people are complaining about, some say that's equally dangerous.
So in terms of the loophole, the government are to close it. Does that clear things up nicely? Does that make it unequivocal?
In terms of that particular law, yes. How they apply it might still leave room for improvement. So, for example, if someone's driving along the motorway with a phone to their ear, happily having a phone call, surely they shouldn't just be prosecuted with the mobile phone law, because it's much more dangerous. And at the moment, the police don't seem to discriminate between the type of use, because it's much easier just to charge a standard mobile phone offence. So I think in terms of the application of the law, the police really ought to look at this.
So how often, when you've dealt with cases where phones have been used, does the driver get off because the police have wrongly applied the rules, but the courts have decided, via the case that you've made as a lawyer, that those rules were applied unfairly? How often is that the case? Well,
often the motorists don't understand they might have a defence. But say, for example, I had one client who came to me. He was literally caught on film, appeared to be with the phone to his ear having a conversation. And he was actually hard of hearing. He had a phone speaker to his ear while he was having the conversation. Now, most people would say, look, that's obviously just as dangerous. But he was acquitted on a submission of no case to answer. In other words, the court accepted the submission that he wasn't actually using his phone contrary to the terms of the regulations. But this is what I mean about the application of the law leaves room to be desired.
So the idea of this new... Yeah, I was just going to say...
realised that and charged him with careless driving or something like that.
Because
he wouldn't... As they propose to amend it, he wouldn't be caught by the new law, because it's not the interactive communication devices he's holding.
So it could still be a grey area, but one assumes the government's attempt to close these sort of what some might see as loopholes and others would say as just grey areas have been done solely for the reason of the kind of moments where you say, well, actually, I wasn't using it for this, I wasn't using it for that. The government are saying we're going to clear all of this up. Any kind of touching, using, communicating is bad and illegal.
Yeah, I mean, I think what the listeners have to appreciate is that there is no law that covers every situation. You always have to have interpretation of the law and then interpretation of the facts by the magistrates. And the police have to, first of all, fully understand what the law is, and then make sure they charge appropriate offences, number one, which is suitable for what the defendant did, and number two, which carries a severe enough potential punishment so that, for example, as I mentioned earlier, someone going along at 70 with only one hand on the wheel doesn't get the same punishment as someone who just quickly receives a text message while he's in a stationary queue.
On that point, Sunil, thank you. Always great to have you on. Sunil Rupasina, who is a motoring lawyer at Kent Traffic Law, with us here on BBC Radio Kent.